All right, folks, take your seats. All right, so we're at the point where both sides have rested their case. We're at the closing argument stage. In just a few minutes, the attorneys will be given an opportunity to summarize the evidence as they see it and to discuss the legal and factual issues that they believe are important. I ask you to pay close attention to what they have to say. I remind you that what the attorneys say is not the evidence. The evidence is what came before you in this courtroom by the means of testimony through witnesses in the form of documents and other tangible items. Now, we'll allow you to take all the exhibits with you into the jury room when you begin your deliberations for you to examine as you see fit. We've got a binder here that has considerable material which you're going to be able to use as you make your decisions. We just ask that you not mark or damage any of the exhibits. Sometimes the attorneys will have a differing view of what a witness may have said or what an exhibit means. Should that happen, you should rely upon your own memory and assessment of the evidence, as it's your view of the evidence that counts. Now, I allow the attorneys to refer to the jury instructions that they see are important, but if that should occur, please consider this in light of all the instructions I give, not just a few ones that are referenced by counsel. After the attorneys have spoken, I will instruct you on the law that you must follow in reaching a verdict. Jury instructions will be in a written form, and you're free to take that into the jury room. We won't do that until we start the deliberations, likely tomorrow. Under our rules of procedure, because the plaintiff has the burden of proof, he will address you twice. He will speak, followed by the defense counsel, and then he'll have an opportunity to make a brief rebuttal. We've given the attorneys equal time to address you. All right, with that, Mr. Tim Panic, you may address the jury.
Yes, Your Honor. Good afternoon, ladies and gentlemen. It feels like only yesterday we were going through the voir dire process to decide whether or not who would be on our jury. And finally we're here. You've heard all the evidence. Now it's time to see, let's review, if it were, what we heard. I told you in openings that our case would be about the facts and circumstances of the case, of this incident. On November the 18th, 2016, Rod Jacobson went with his dog, Candy, to the property that has been mentioned numerous times. That dog and Mr. Jacobson have been on the property numerous times by everybody's testimony. They were there to decorate the boat for the Venice Boat Parade. As Mr. Jacobson told you, the boat was her happy place, a place where she felt safe. Mr. Jacobson arrived, and as we stated, Candy decided to seek refuge from the sun underneath the truck. Mr. Jacobson walks towards the docks, where his boat is docked, at the permission of his friend, D. Deaterly, the grandfather of the defendant, Zachary Deaterly. He walks, and he hears a voice yell, "Hey, Rod." And he starts to come back. In the process of walking back, he sees Mr. Deaterly kick dirt at Candy. And he walks up to grab a hold of the collar. And as he's doing that, because obviously he turned away to grab Candy, bullets start to fly. Mr. Jacobson cannot actually believe what he hears. He's in complete disbelief. And as you heard from the veterinarians, that bullet wound came in the left side of the dog. Immediately, dog takes off, runs to the place where she feels safe, the boat. Mr. Deaterly continues to fire. By his own admission, the first time he speaks to law enforcement, he says he fired 3 shots, but doesn't remember hitting anything. So that's the day after the incident. 5.5 years later, to you, last Friday, he tells you, I missed on the first shot, I missed on the second shot, but hit the dog on the third. Yet, we have testimony from 2 veterinarians who have experience treating gunshot wounds, as they stated, and they noted a suspected second gunshot wound on the right elbow of the dog. The dog, if it's facing Mr. Deaterly face to face, as he claims, shooting across his body to be able to hit that point. Unless the dog's running away and his body's turned around and running, she's running towards the dock. So now her back is to Mr. Deaterly and her right elbow is parallel to where Mr. Deaterly would be firing the gun. Immediately after the incident, Rodney Jacobson, still in utter disbelief at what had just transpired, turns to Mr. Deaterly and says, "Did you just shoot my dog?" Defendant's own admission, on the stand, "You're damn right I did." He tried to tell you about how remorseful he was, yet immediately after the incident, he called Mr. Jacobson an effing moron. I'm going to pull back the language. We've already heard it enough in this courtroom. Effing moron. GD idiot. Brandishing the firearm at him. Does that sound like somebody who's truly remorseful? You're damn right I did. That's not something you say to someone right after you shoot their dog, even if you are in fear for your life. That's something you say to someone when they ask you whether or not you ordered the code red. It's just not in reality. Mr. Jacobson, still in disbelief and fear for his own safety after multiple gunshot wounds just went off right next to him, and in fear for a man who's brandishing and shaking a firearm, taunting him, fearful that that man is going to turn the gun on him. Without thinking about himself, he goes to the boat and he used the trail of blood from Candy's bullet-ridden body. And he finds her on the boat, on a bunch of life jackets, bleeding profusely, moaning. And from there, he grabs the dog, not thinking about anything, and walks her back to the vehicle, not knowing that one of his tires is blown out. And he drives to this Blue Pearl veterinarian clinic. And he explains what actually happened. And as you see in the medical records, and as both Dr. Ellis testified, multiple gunshot wounds. Multiple. Meaning more than one. And when I asked Captain Tudko about the investigation, well, actually we'll get to that. From that incident, he has to put down $2,700 for emergency surgery. That's what he had to pay. And eventually a decision was made to transport Candy to Tampa from Sarasota. And Rod rode with her in the ambulance as she was transported. She met Dr. Morris up there, who also suspected the wound we pointed out on the right elbow was a gunshot wound. Multiple gunshot wounds. Despite their best efforts, Dr. Blyert's as well, who you heard from today, Candy passed away. The cause of which was a gunshot wound from the gun fired from Mr. Deaterly. Undisputed. My first question, did you shoot and kill Candy the dog? Yes, I did. There's no issue as to causation about who actually fired it, whether the bullet itself caused her death. There's zero doubt. Subsequently, following that incident, a few days passed. Obviously, Mr. Jacobson had to tell his wife that Candy had passed away. Same wife and him who adopted Candy in 2014 to save her from being euthanized because she was pregnant, and she eventually gave birth to 12 puppies. The dog that went everywhere with Mr. Jacobson, to every job site, every car ride, every boat ride, everything. That man right there was Candy's best friend. And he sat there and watched her get shot. Defense is going to try to say that what defendant said was true, that he did nothing. Based on everything that you heard, the pictures on the boat, in the car, everywhere, the testimony, does that seem believable? That the guy who loved this dog more than life itself decides when it's in a confrontation with somebody else to just stand there and be like, I'm not going to do anything? No, it's because it didn't happen. He walked up, and he was in the process of trying to grab her collar, and that's when Mr. Deaterly shot. There's no dispute. Candy didn't even lay a paw on Mr. Deaterly. Didn't even get a teeth mark into it. One piece of fabric on his clothing. Nothing. Nor did she ever do that to anyone. Never bit anyone, never jumped on anyone. She does other of those things to Mr. Deaterly. I'm not sure we're here right now. But she didn't. You heard from Leanne Novak. Similar story to Mr. Deaterly. Never met the dog before. And she was able to walk right up to the dog with the window down, dog in the back seat, unleashed, nobody there. Candy didn't bark, growl, snarl, anything. She just allowed Miss Novak to pet her. Dr. Bonda talked about how Candy had come to him 5 separate times. All the times weren't pleasant. She's getting blood work done. And yet, she never shows any aggression towards him. Never bites anyone. Never jumps on another dog. We're in a pinch collar for the reasons that anybody puts on a pinch collar on a dog. That was Candy the dog. And subsequent all of that, law enforcement opens an investigation to Mr. Deaterly. You saw the supplement day after the incident. They ask him, Mr. Deaterly, his side of the story. Don't even ask him to write a written statement. They asked my client to write a written statement, but not the defendant. I asked Captain Tugco, Sergeant Akil, okay, did you guys go up to the scene, take pictures, figure out? No, we didn't think it was necessary. Well, my client was claiming at least 3 gunshots were fired, if not more. Test the gun for ballistics? No. Did you talk to the veterinarians to find out any medical terms that you didn't know? No. How did you find out the medical terms you didn't know? Google. And I ask because still in disbelief. Why wouldn't you simply call the veterinarians? I asked, you have the medical records? Yes. On the top of those medical records, they have the phone number to the veterinarian clinic. And if they had a question about anything, wouldn't it make sense to just simply pick up the phone instead of Googling it on a criminal investigation? That doesn't sound like a thorough investigation to me. Captain Tudko used those very words earlier today, a thorough investigation. That's not a thorough investigation. This is what somebody said to me. Okay, sounds good. I'm going to take them at their word. Not do anything with it. Not to investigate further. Not to ask questions you don't know the answers to, but rather type in words in Google. And if they asked, they would have said, yeah, we knew one gunshot wound for sure, and we suspected another one. And I asked them, I asked both Sergeant Akil and Captain Tudko, are you guys experts in gunshot wound analysis? Answer, Sergeant Akil, no. Captain Tudko, no. Okay, Captain Tudko, you oversee animal investigations, correct? Yes. And you've done thousands of investigations. How many investigations have you done for an animal homicide? Answer, none. They didn't do an investigation because they didn't know how to do one. And you look at the photographs that were taken by the sheriff's office and Candy's bullet-ridden body. You could see exactly what the veterinarians were pointing to, the wound on the right elbow, on the left side of the dog. They saw it, but law enforcement didn't, and nor did they follow up at all. Defendant took the stand. And he tried to, I don't know for what reason, tried to tell a different story than what he told law enforcement. He told them, I don't remember if I hit anything. That's what he said, right after the incident, 5.5 years ago. And what did he say? Well, I hadn't eaten, I hadn't slept, I haven't drank any water. But that's the statement that he gave to law enforcement, and they eventually declined criminal charges. Yet now, he was able to tell you that he missed twice and then he hit the third time. Why? It's actually kind of smart, in my opinion. It's because when you say you missed the first 2 shots, you can use those by saying, I did try to do warning shots with Candy. I was shocked when she didn't do anything after the first shot. Really? You shoot at a dog, it doesn't do anything, it keeps coming at you, but it never did keep coming at you, Mr. Deaterly. It didn't. I never got within 2 feet. It was simply barking. The only time the dog got any closer was Mr. Deaterly kicked dirt at it or kicked it in the head. It didn't even get so much as one bite mark, one paw on him. How is that self-defense? How is it that a dog deserves to be shot simply for barking? I heard what he said about it just kept coming in an attack. What attack? Running around and then stopping and barking? That's an attack? It's not. An attack, for me, as I understand it, would at a minimum involve at least just a paw mark on Mr. Deaterly. Not even so much as a bite mark, just even a paw mark. Landing a paw on him. She didn't. She'd been over at that property countless times. You heard from Brian Williams. He had a similar incident, dog barking, running around. Mr. Williams doesn't shoot Candy. Never even thinks to. She just shoos Candy and she's on her way. You heard from Richard Moldaville, who still works for defendant's father for the last 26 years. And he tries to tell you about an aggressive incident of a dog, of Candy the dog, jumping and barking in the car. When I asked him, is the window open? No. Door open? No. Who hasn't had a dog bark at them from inside a car? That's considered aggressive? And even when you think of Dr. Hopp's testimony, when you hear about the different bark noises, aggressive versus non-aggressive, I honestly couldn't tell the difference, and I honestly couldn't believe that was testimony. What is an aggressive dog? Not Candy. Not according to the people who knew and loved her so much, and even the people who just interacted for even a brief moment. And even the people defense introduced talk about the aggressive incidents. She didn't bite them. She didn't jump on them. She barked at them. Dogs bark. That's the truth. Subsequent this whole incident, as you heard, defense counsel's own witness, almost 3 years later, Mr. Jacobson is still crying, sobbing, were the exact words of Dr. McGovern over this incident, 3 years later. Because he went and saw Dr. Edlin, and you remember his testimony. He was the one who actually diagnosed him with PTSD. Based on what he was saying, and he broke down for you exactly why. Reliving terror over and over again. Nightmares where you sit there powerless to do anything. That's exactly what you heard from Mr. Jacobson. And his wife said the same thing. And it's so bad, they sleep in separate bedrooms because of that. Because those terrors are so bad. Defense counsel talked a lot about his not reporting it to August 15, 2018. Here what I asked Dr. Mark Antonio. Do people always tell you what's ailing them right after immediately happens? No. Does sometimes it take months or years? Yep, possibly. So bad, he went and saw Dr. Edlin. He's the one who actually diagnosed him with PTSD. Dr. McGovern takes the stand and says, no, based on my evaluation, he doesn't have PTSD. Yet he's never been qualified as an expert in post-traumatic stress disorder. And when I asked him about it, it was like, have you testified in cases? No, none that I could think of. And the fact he's also getting paid by the defense. And you heard the amount he was actually getting paid per hour. And that went on for years. Reliving the same day, and it still sometimes does, over and over again. Rod sees Candy in his dreams, getting shot over and over and over again, reliving it, as if only a bystander, to be a bystander, just to watch. That's endless. It's on endless loop. That's not something he's ever going to forget. Charged with 3 counts. There are 3 counts in this complaint. First, intentional infliction of emotional distress. Rodney Jacobson has alleged that Zachary Deaterly intentionally inflicted emotional distress on him by firing his gun and acting with malice and intent to kill his dog. Rodney Jacobson further asserts that Zachary Deaterly deliberately caused severe emotional harm, and that Zachary Deaterly's conduct was so outrageous in nature and so extreme in degree that it was atrocious and utterly intolerable in a civilized society. All of those people, the maintenance crew on Mr. Deaterly's family's property, which was previously owned by his grandfather and father and aunt. Maintenance crew. Candy Barrow numerous times. Ran around. No issue with them. Brian Williams. Barking at him. Brian doesn't shoot. No. This dog went to job sites where power tools are being used. Countless people. Everywhere. In the car, in the boat. Yet, none of those individuals ever shot Candy the dog. Deaterly's conduct was so outrageous in character and so extreme in a degree that it was atrocious and utterly intolerable in a civilized society. He's on the stand and he's telling exactly what his options were. The truck is to the east. Understand. The dog, by his own testimony, this is just based on him, controls the south. Okay. He says that the waste area to the north was muddy. Okay. But then I ask, you called out to Mr. Jacobson, correct? Yes. So you knew by saying that, you suspected that the dog you encountered was Mr. Jacobson's. Yes. And he testified that he saw Mr. Jacobson walking towards on the shell path towards the dock when he turned around. Yet he never, I understand he didn't want to turn his back, and I wholeheartly understand. But he didn't need to. Like I was showing to him, could you just simply keep your eye on the dog and just walk over to where you know Mr. Jacobson to be when you suspect it's his dog? He didn't have an answer for that. And when I ask him how far it is, he says, well, I don't know how far the distance is. He was able to tell you that the dog was in a few feet of him, a few inches actually, in this spur-of-the-moment incident. But by his own admission, he couldn't tell you how far the dock was on a property. By his own admission, he'd been to thousands of times. Does that sound believable? No. As a result, you must decide whether Zachary Deaterly's conduct was intentional. He didn't just fire once. He didn't fire twice. He fired at least 3 times. Intentional. Of a dog that didn't even lay a paw on him. He had to squeeze the trigger 3 times. At least. He knew if he intended his behavior, knew or should have known it was emotional distress would result. Any reasonable person would know that if you shoot somebody's dog in front of you, that's not something you forget. You must then decide whether Zachary Deaterly's conduct was extreme and outrageous. Extreme and outrageous conduct is behavior which, under circumstances, goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized society. Shooting the dog, and not just shooting it, shooting when it's running away. That's how it got hit on the right elbow. Because the dog was parallel. Right hand, dog turned, right side is exposed. Just as how the bullet went in the left side, dog's left side was exposed. That action is shocking, atrocious, and utterly intolerable. This dog was barking at Mr. Deaterly. Staffordshire Terrier, that's what was barking. And I heard a lot about it's a vicious pit bull. That's implicit bias. That's basically saying that since it was a pit bull, that it was by nature vicious. And you heard multiple witnesses. Just because some dog is a pit bull doesn't make it vicious, or any dog. But that's what he needs to convince you of, to justify. It was a pit bull. Ooh, scary dog, could hurt me. Yet it doesn't. And it didn't to anybody who ever come into contact with it. You must then decide whether Zach Deaterly's conduct caused the emotional distress. Extreme and outrageous conduct is a legal cause of severe emotional distress if it is directly, in a natural and continuous sequence, produces or contributes substantially to producing such severe emotional distress, so that it can reasonably be said that but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. You heard from Dr. Edlin, who is the one who actually diagnosed Mr. Jacobson, post-traumatic stress disorder. You heard it. You heard his testimony. You heard of his wife's. The conduct, he finds himself chasing Zach in the middle of the night in his dreams, watching Candy get shot over and over and over again. That's 5.5 years since this incident. And even Dr. McGovern said he sobbed right to him, their first meeting, almost 3 years after the incident. Finally, you must decide whether the emotional distress was severe. Emotional distress is severe when it is such intensity or duration that no ordinary person should be expected to endure it. Significant feelings of fright, shame, worry, and humiliation occasioned by the acts of others, even if regrettable and unavoidable, to prove a claim of intentional infliction of emotional distress, the plaintiff's evidence must sufficiently buy the greater weight of the evidence. Like you heard in the testimony, that went on for years. Sobbed for 10 seconds, 3 years later. Woke up in the middle of the night, screaming and crying, many a times before. Of such intensity or duration that no ordinary person should be expected to endure it. Cindy Watson and Rod Jacobson not sleeping in separate bedrooms because it's a no issue. No, it's because it's of such intensity or duration that no ordinary person should be expected to endure it. Nobody should ever have to watch their pet, their best friend, be shot right in front of them for doing what dogs do, and that's bark. And bark at strangers. Negligence. So the second count is dealing with negligence. Negligence is the failure to use reasonable care, which is the care that a reasonable person would use under circumstances. Negligence is doing something that a reasonably careful person would not do under like circumstances, or failing to do something that a reasonably careful person would do under the circumstances. Summary of the claim. Rodney Jacobson has alleged in this case that Zach Deaterly was grossly negligent, malicious, and reckless by shooting his gun. That's pretty clear. Mr. Deaterly was looking for a reason. So why else? Why else would you shoot him? Why else would you shoot Candy? A dog that's stopping and barking at you, who wasn't on top of you, wasn't biting you, but was barking at you. And the response? To shoot it. To shoot her. There was a lot of mention, I think, during the defendant's own testimony of calling it. Candy was not an it. Candy was a she. And she was Rod Jacobson and Cindy Watson's dog. Until Zachary Deaterly killed her for barking. In order to prove this claim for negligence, Rod Jacobson must establish 3 elements. The existence of a duty recognized by law requiring the defendant to conform to a certain standard of conduct for the protection of others, including the plaintiff. By Mr. Jacobson's own testimony, standing shoulder to shoulder, walking up, trying to get a hold of Candy. Candy's turning towards him. And Mr. Deaterly says, well, I didn't see him. He started shooting. He wanted to get Rod's attention so much, yelling for him, get your dog off me, that he makes no attempt to actually try to go over to where he knows Rod is. And why would someone do that? Because you know exactly where Rod is. He's right next to you. The story doesn't make sense otherwise. But the guy who loved his dog more than life just sits back, sees him kicking, barking, circling, as Mr. Deaterly said, circling around into 3 separate attacks. But also, what doesn't make sense, the defendant said he shot once, nothing, dog didn't react. And Mr. Jacobson just was nowhere to be found. You heard from him. He was in the Coast Guard. Firearm owner. Fired guns himself. He knows exactly what he heard. There's no doubt about it. So the defendant's testimony, shot once, nothing. Dog didn't do anything. Dog didn't react. Shot again. Mr. Jacobson does nothing. Candy continues her attack. Really. And then it's not until the 3rd one that actually is a hit that she actually takes off. If that were true, Mr. Deaterly's story just doesn't make sense. He's so sorry, remorseful. You're damn right I did, when asked if he shot the dog. You're damn right I did. An effing moron. Idiot. Like he said, I'm not using the language. It's already been used more times than we can count. Second, a failure on the part of the defendant to perform that duty. Zachary Deaterly had an absolute duty to do everything in his power to prevent this from happening, and he just didn't. He just didn't. This dog is not on top of him. This dog is not biting him. This dog is barking at him. And instead of simply just walking to where he knows the owner is, or he suspects it is by his own testimony and what he drew, just stands there. Understandably, the waste area to the north, the cars to the east, and the dog controls the south. There's nothing stopping Mr. Deaterly from walking west and keeping his eye on Candy while he walks to where he knows, he suspects his owner is, her owner is. Leanne Novak came in contact with Candy, no issue. Was able to pet her, first time they ever met. Dr. Bonda, same thing, including giving her shots. Never barks, never growls. Brian Williams, same thing. Barks, growls, nothing. No issue. She said she was searching for lizards, like she always did on the property, that she'd been to so many times. An injury or damage to the plaintiff proximately caused by such failure by the defendant. Candy the dog was shot and killed. And as a result of that, in trying to save her life, he spent $2,700 at Blue Pearl, Sarasota, and another $5,500 at Blue Pearl, Tampa. In addition to nightmares that are never going to go away. Time will be a flat circle for Mr. Jacobson. He will relive that moment forever. Finally, count 3, assault. Rodney Jacobson asserts that Mr. Deaterly assaulted him by willfully discharging his firearm while in close proximity and by maliciously brandishing it with the intent to put Mr. Jacobson in apprehension of immediate harmful contact, and that Mr. Jacobson was put in that apprehension. You heard what Mr. Jacobson said. You heard what the defendant said. You're damn right I did. After shooting the dog numerous times. Effing idiot. God. No, you know what he said. Does that sound? That sounds like somebody who was angry. By his own admission, on that stand, he said he was angry. That supports something who is angry. And when Mr. Jacobson said, yeah, he was brandishing at him, Mr. Jacobson had just watched as Mr. Deaterly shot his dog. And he immediately, yeah, you're damn right I did. That sounds like somebody who's proud of what they did, not someone who's sorry for what they did. Assault is defined as an intentional, unlawful offer of corporal injury to another by force or force unlawfully directed towards another under such circumstances as to create a fear of imminent peril, coupled with the apparent present ability to effectuate the attempt. Brandishing the gun at him, huh? Yelling obscenities immediately after just shooting his dog. Showing no remorse for it. Bullets flying. Yeah, he absolutely was in fear that Mr. Deaterly was in fact going to turn the gun on him next. Those words. Mr. Deaterly thought he could fool you with his testimony on Friday. Tell the story, yep, I missed first 2 shots. It says to law enforcement a different story. I don't know if I hit. Right after this incident. When I asked him questions, did you call him this? He said, I didn't say that. I'm like, did you say he was? You're damn right I did. Yes, I did. That kind of obfuscation or deviousness is somebody who knows they're busted. Caught in a lie. And not just one, numerous ones. The reason he had to admit it is because he took a deposition. And he's like, yeah, I said those things. He couldn't now turn around and say something different to you. But he did try to convince you that he was remorseful from that. But remember the last thing I did. I took out the picture of Candy's bullet-ridden body, and I showed it to him. Nothing on his face. No reaction, no remorse, nothing. Stone-faced. That is not somebody who is remorseful. His words, he admits them. His actions say all he needed to. Defense tried, like I said earlier, defense tried to hide, basically saying that, oh, well, he wasn't criminally charged and they did a thorough investigation. You heard exactly how thorough that investigation was, if you even want to call it that. I certainly would. I would absolutely not call that investigation.
Counsel, you have 15 minutes.
Defense counsel is going to speak to you about this case. And then I'm going to speak to you one last time. And when we do, I'm going to be asking you to find Mr. Deaterly liable for the death of Candy. And find him liable for intentional infliction of emotional distress, negligence, and assault. Thank you.
May it please the court. Good afternoon, ladies and gentlemen. James Madison once said, in suits of common law, trial by jury in civil cases like this is as essential to secure the liberty of the people as any one of the pre-existing rights of nature. In that regard, jury duty should be viewed as both an honor and a privilege. These past 2 weeks have been quite an experience for you, but each of you have handled your duty as jurors in this case with diligence and resilience. And this is an experience that you would never have had if Mr. Jacobson had his dog leashed. For your service as jurors in this case, I want to thank you on behalf of myself, Attorney Johnson, and Mr. Deaterly. When you go back to retire for deliberation, you're going to be handed jury instructions, you're going to be handed a verdict form. The very first question on that verdict form is going to ask you to answer the question, did Mr. Deaterly act in self-defense? If your answer to that question is yes, self-defense is an absolute bar to any of the other claims that Mr. Jacobson has brought here today. If you find that Mr. Deaterly acted in self-defense, your service as jurors will have been concluded at that point. Let's talk about self-defense. To show self-defense, Zach would have to show 3 separate requirements, and this is all going to be in the jury instructions that you're going to get when you retire back for your deliberation. The first is whether or not the dog's actions led Zach to reasonably believe that the dog was going to inflict harm on him. It's question number 1. The second question is death or injury to the dog reasonable in view of the gravity of the harm that was threatened by the dog. If Mr. Deaterly believed that the dog was going to inflict the harm, and if Mr. Deaterly reasonably believed that he had no other option but to shoot the dog, he would act in self-defense. The third element that you're going to have to look at is that Mr. Deaterly believed that harm could only be prevented by the immediate death or injury of the dog. Mr. Timpanic went through what his view of the facts are. Let's talk a little bit about the facts supporting self-defense in this case. The dog, 60 pounds. unleashed. It approached Mr. Deaterly after Mr. Deaterly yelled out to Mr. Jacobson. It came from behind bushes on the side of a wooden shed on a densely vegetated and densely wooded piece of property. The dog not only approached Mr. Deaterly once, it approached him several times. And during those several times, Mr. Deaterly made several attempts to stop the dog. He yelled at the dog. He stomped the ground at the dog to try to scare it away. He kicked dirt at the dog. Mr. Jacobson even acknowledged seeing Mr. Deaterly kick dirt at the dog. Mr. Deaterly kicked the dog in the head to try to scare it away. That didn't scare the dog away, that only made it even more angry. After Mr. Deaterly kicked the dog in the head, the dog came back around for a final pass. It lunged in and out at Mr. Deaterly multiple times. And throughout this entire time, Mr. Deaterly is yelling to Mr. Jacobson for him to do something about his dog. And if you look at the complaint, if you heard Mr. Jacobson's testimony, this dog had specialized training. It knew how to sit, it knew how to come when called, and knew how to lay down. Basic commands that everybody teaches their dog. If the dog had such specialized training and was so good at when being called, why did Mr. Jacobson not yell out to the dog? Why did Mr. Jacobson not do anything to get his dog under control? That's because, as Mr. Jacobson told Sergeant Achille, he had never seen his dog act that way before. Mr. Jacobson was shell-shocked. He didn't know what to do. That dog was going after Mr. Deaterly, and he panicked because he had never seen his dog act that way before. Even despite the efforts of Mr. Deaterly to try to kick the dog away from it, after it made several passes at him, after he couldn't back up anymore because he risked falling into a mud pit, after he yelled to Mr. Jacobson, the dog came in on one final lunge, and you heard Mr. Deaterly testify. When it came in on the final lunge, it's baring its teeth. It was snarling at Mr. Deaterly. The hair on the dog's back was standing up at Mr. Deaterly. It was only then, and after he had already tried all those other things to keep the dog away from him, while Mr. Jacobson stood silent doing nothing, that Mr. Deaterly had to take out his gun and shoot the dog. Otherwise, he risked injury. Mr. Timpanic liked to point out the fact that Mr. Deaterly was not bitten. He had no bite marks. His clothes weren't torn up with the dog's teeth. Thankfully, that is true. But had Mr. Deaterly fallen in the mud pit that was directly behind him, it could be a totally different story. And if you take Mr. Deaterly's testimony and you combine that with the pictures of the animal that show where the gun entrance wound was, compared with the x-rays of the animal that show where the bullet lodged with no exit wound, Mr. Deaterly testified he shot from his hip. He pulled out his gun, he shot from his hip, and shot 3 times. The dog was right here. The bullet entrance was on the left side of the dog, travels front to back in a downward motion. It's not indicative of a gunshot of a dog running away and being shot in the back, as Mr. Jacobson would like you to believe. Mr. Jacobson knew that his dog was aggressive. You heard testimony that he knew his dog was aggressive. Mr. Jacobson received the dog from Manatee County Animal Services, who picked it up wandering off the streets. Did he do a noble service in taking the dog in while it was pregnant and allowed the dogs to give birth? Absolutely. That was a noble thing to do. But having the dog unleashed on that property was an injustice to that dog. When he got the dog, he observed that not only did it have scars on its head, but that it had scars on his back. all indicative that the dog had been abused. In fact, Mr. Jacobson himself said it really looked that the dog had been abused because of all the scars on the back, and the scars on the head of the dog. Mr. Jacobson even told Brian Williams to be careful around the dog. Why? Because Mr. Jacobson knew nothing about the dog's background and was scared that it might hurt somebody. You heard Mr. Williams testify that when the dog got outside of the confines of the property, that Mr. Jacobson was concerned, that he was afraid of what his dog might do, because he knew that his dog was aggressive. In fact, when Mr. Williams came on the property and had interaction with Mr. Jacobson and the dog, Mr. Jacobson would put the dog into the truck. So that way Mr. Williams didn't have to worry about the dog being out and about on the property. Indicative of the fact that Mr. Jacobson knew that the dog was aggressive. Richard Mulvihill testified that he walked by the truck and the dog lunged out at him. He said that was similar to the characteristics of a pit bull that had charged through, or that had chewed through, a chain link fence at the pound that he owned, the kennel that he owned. He was so afraid of that dog that he took his family and he put his family inside of the vehicle so that way they didn't have to worry about the dog getting out of the truck. And then Mr. Mulvihill did the noble thing and continued to assist Mr. Jacobson in unloading and loading gear off his boat and into his truck. Mr. Jacobson knew that the dog was so aggressive that he had to use a prong collar. And despite Dr. Bonda's testimony that he was able to draw blood and the dog didn't react to it or anything else like that, he still had to have a prong collar on the dog when it got an x-ray. You've seen the pictures. In order to control the dog by using a prong collar, it was necessary for that dog to have a collar of that type around its neck while it was getting an x-ray. Not only did Mr. Jacobson use the prong collar when he went to the veterinarian's office and had an x-ray, you also saw pictures of Mr. Jacobson using the prong collar while he had the dog out on his 56-foot boat, the dog's happy place. Why? Ask yourself why. The 56-foot boat was parked at the Venice Yacht Club. What did Mr. Jacobson have to do in order to get onto his boat? He had to go in and out of the Venice Yacht Club around other people. What did he do? He had the dog on a leash, and he had a prong collar around the dog to make sure that it didn't jerk or do anything else to get away from him, to keep it under control, because he knew that his dog was aggressive. You heard Zach testify. Let me back up. You heard Captain Tutko testify as well that Mr. Jacobson told him that the dog was just doing what dogs do, and he took that to mean that the dog was protecting its owner. And again, Mr. Jacobson had never seen his dog act that way before. You heard Zach testify that as the dog continued approaching, he was fearful, that he could not retreat, did not feel comfortable turning his back on the dog because at all times the dog was running. As it was circling around and coming in, it was running. It never stopped running. And like I said before, thankfully he did not fall. And then we go to the testimony of Mr. Jacobson and Miss Watson regarding the dog. They kept the dog in a separate room at their other house.
Excuse me.
Yep.
You okay? All right. If there's no problem.
No, you're okay.
Go ahead, sir.
Okay. You heard them testify that the dogs were allowed to be around each other, that they only kept the dog separate from the other dogs at the house only after it was pregnant and after the babies had been born. But yet you heard Miss Watson get impeached with her own testimony during her deposition where she said, we keep the dog separate from the other dogs of the house because of my aggressive poodle. You heard Brian Williams testify that Mr. Jacobson told him himself that he took the dog out to the property So that way he didn't have to be around the other dogs at the house. They kept it separate. They knew it was aggressive. Even Mr. Jacobson himself acknowledged that Zach felt afraid when he shot the dog. We played the clip for you during his testimony, wherein he acknowledged that. And it was only until after Mr. Jacobson did nothing to control his dog, and the dog came within inches of Zach and was about to bite Zach, that Zach pulled out his revolver and shot the dog. That's not an issue. Mr. Deaterly has never said that he never shot the dog. He did. When considering the evidence leads to three conclusions. Zach knew or reasonably believed at the time that the dog was lunging in front of him, baring its teeth, snarling at him with its hair raised on the back, that dog was going to inflict harm upon him. That dog was going to bite him. The evidence shows that the death or injury to the dog was reasonable in view of the gravity of the harm threatened. The evidence also shows that Zach reasonably believed that harm to himself could have only been prevented by shooting the dog. He exhausted all other options that he had before he pulled out his firearm and shot the dog. He yelled at it. He kicked it. He stomped the ground. He kicked at it. He yelled to Mr. Jacobson to get his dog under control, but Mr. Jacobson did absolutely nothing. Mr. Deaterly acted in self-defense in shooting the 60-pound pit bull that was staring him down. As Mr. Timpanic mentioned, the first cause of action is intentional infliction of emotional distress. Okay? There's three questions that you're going to have to ask. Or excuse me, 5 questions that you're going to have to answer, that you'll be asked to answer. The first question is whether or not Zach's conduct toward Mr. Jacobson was deliberate or reckless. Even though Zach shot the dog, he was justified in doing so, and did not do so in an effort to cause Mr. Jacobson emotional distress. It was self-preservation at that point. In shooting the dog, Zach did not act recklessly in shooting the dog. The second question that you're going to ask, or you're going to be asked to answer, in the event that you don't find self-defense, is whether or not Mr. Jacobson suffered extreme emotional distress of such intensity or duration that no ordinary person could be expected to endure it. Let's go through the facts. Mr. Jacobson had pre-existing depression for 20 plus years. He had taken 50 milligrams of Zoloft for several years prior to the incident. When Mr. Jacobson was deposed, he wanted everyone to believe that he weaned himself off of Zoloft. If we can play clip 49.
Did he prescribe you any medication?
Yeah, I was on Zoloft for a while.
How long were you on Zoloft for?
Probably, I only saw him a few times, but it probably a year after that. And then I saw my another physician and weaned myself off it.
That's what he testified to in his deposition. But when we got the medical records, he had in fact taken Zoloft continuously for 20 plus years. He didn't wean himself off Zoloft until 2018, after he allegedly went to his doctor with a worsening symptoms of his already pre-existing depression, as Dr. Mark Antonio testified to while we went through the medical records today. Mr. Jacobson visited with Dr. Mark Antonio 4 days after the incident in this case occurred, but yet mentioned nothing to Dr. Marcantonio about the incident, mentioned nothing about a worsening of his already pre-existing depression, didn't even feel that it was necessary to tell his doctor about the incident. In fact, Mr. Jacobson filled out an annual wellness exam form either before or during that visit that Dr. Marcantonio went over Mr. Jacobson with. If I can get Exhibit 10. Mr. Jacobson did not mention the incident or any worsening of the pre-existing depression. On the annual wellness exam form that he filled out, that he reviewed in great detail, you saw Dr. Marcantonio's records, reviewed annual wellness exam form in great detail. Mr. Jacobson did not indicate any depression over the prior 2 weeks. He did not feel little interest in doing things. His feelings did not cause him distress or interfere with his ability to interact socially with friends. He almost never felt sad or depressed the prior 6 months. Stress was never or rarely a problem for him, and he was able to cope effectively with the stress. A year later, a year after the incident, on November 29, 2017, he filled out another annual wellness exam form, which is Exhibit 11. On Exhibit 11, a year later, he filled it out. He met with Dr. Marcantonio, and Dr. Marcantonio again said in his records, reviewed annual wellness exam form in great detail. A year after the incident with his dog occurred, which allegedly caused him such severe emotional distress, Mr. Jacobson reported never feeling sad or depressed the prior 2 weeks, that he almost never felt little interest or pleasure in doing things, that his feelings did not cause him distress or interfere with his ability to interact socially with friends, and that during the past 6 months, he almost never felt sad or depressed. In fact, he indicated that he was able to cope effectively with the stress in his life. He was able to cope effectively and had no stress in his life, that he visited his primary care physician, Dr. Marcantonio, 10 times before he ever came to him with a worsening of his already pre-existing depression. And when was that? When was that? That was 2 days after he received notice that his medical records were going to be subpoenaed for this case. We can't have medical records be subpoenaed and not have any mentioning of this incident. So 2 days later, on August 15, 2018, after he received notice that we intended to subpoena his medical records, he presents to Dr. Marcantonio. Not only does he present them to Dr. Marcantonio, but his wife accompanies him. He has worsening depression as a result of seeing his dog get shot, and post-secondary issues related to his divorce, which would be the alimony modification that Mr. Jacobson was unsuccessful. He was unsuccessful in it at the trial court level. He appealed that decision, was unsuccessful at that time. Spent over $600,000 in pursuing that action. The 10 visits that Mr. Jacobson had with Dr. Marcantonio included things for wellness visits, right shoulder pain, follow-ups, deep cough, persistent cough, cough and congestion, redness resulting from removing a sliver in his arm, scratch on the left side of his face, but no mention about any worsening depression symptoms. During this time, from November 22, 2016 to August 15, 2018, Mr. Jacobson traveled to Ireland. He didn't stop working. He didn't stop boating. He didn't stop fishing. despite Cindy Watson sitting there on the witness stand saying, my husband didn't boat, my husband never fished after this incident, and Mr. Jacobson having to testify, well, that's not true because I did boat and I did continue to fish. As a result of the visit on August 15th, 2018 with Dr. Marcantonio, his dosage of Zoloft was increased from 50 milligrams to 100 milligrams. At that point, as we went through Dr. Marcantonio's testimony this morning, Mr. Jacobson would have had 1.5 months left of Zoloft. Mr. Jacobson testified Dr. Edlin never prescribed him medication. Dr. Marcantonio testified, I never prescribed him medication in 2018 or 2019. A month and a half after August 15, 2018, Mr. Jacobson, assuming that he was taking it as prescribed, would have run out of his antidepressant medication. Yet, as he routinely called Dr. Marcantonio to refill prescriptions or for new refills, he did not do so. As a result of the August 15, 2018 visit with Dr. Marcantonio, he was referred out to Dr. Edlin. You heard Dr. Edlin testify. Let's go through Dr. Edlin. First visit, 6 weeks after that, on September 26, 2018. Dr. Edlin met with Mr. Jacobson for about an hour. Dr. Edlin increased the Zoloft dosage from between 125 to 150 milligrams as tolerated. So now we've taken that 1.5 month supply, a month later, so there'd only be a half a month left, and we've essentially reduced it to nothing. The second visit that Mr. Jacobson had with Dr. Edlin was on October 30th, 2018. Lasted for 30 minutes. No change in the treatment plan from the prior visit. The third visit with Dr. Edlin occurred on December 3rd, 2018. Again, meeting with Dr. Edlin for 30 minutes. No change in treatment plan from the prior visit. The fourth visit occurred on January 25th, 2019. They again met for 30 minutes. No change in the treatment plan from the prior visit. And in fact, Mr. Jacobson was getting better. The fifth and last visit that Mr. Jacobson had with Dr. Edlin occurred on May 29, 2019, 4 months after his most recent prior visit in January of 2019. Met again with Dr. Edlin for 30 minutes. No change in the treatment plan from the prior visit. After that visit, Mr. Jacobson stopped seeing Dr. Edlin. Why? Mr. Jacobson said 2 reasons. One, Dr. Edlin stopped taking Medicare. Why is that relevant for purposes of our discussion here? One, Mr. Jacobson never paid a single dollar for his treatment. Dr. Edlin testified that he billed Medicare, and Mr. Jacobson testified he never paid Dr. Edlin any money for the treatment because it was paid for by Medicare. The second reason was because now that Dr. Edlin was no longer taking Medicare, he was going to charge him $210 for each 30-minute visit. And according to Mr. Jacobson, that was too costly. You've heard the evidence. You've seen the evidence. You're a resilient jury, okay? $210 was too costly for a man that spent $600,000 on an alimony modification case. $210 for 30 minutes was too expensive for someone who spent, at that point in time, $100,000 on this case alone, yet did not pay any money to seek treatment. Mr. Timpanic mentioned that we had Dr. McGovern up here testify. Yes, we hired him to testify as an expert to examine Mr. Jacobson, but let's put this into perspective. Dr. Edlin met with Mr. Jacobson a total of 3 hours over 5 visits. Never conducted any objective testing whatsoever on Mr. Jacobson. Relied on Mr. Jacobson's self-report regarding his symptoms. Now keep in mind that Cindy Watson, his wife, is a nurse, and that PTSD symptoms are commonly known, in contrast, Dr. McGovern spent 8 hours with Mr. Jacobson, conducted multiple objective tests, definitively ruled out PTSD, definitively ruled out other diagnoses and disorders, except for persistent depressive disorder that was attributed to Mr. Jacobson's long-term depression that had extended well before the incident in this case occurred, and still continues to today. As you will see in the records, when you go back to deliberate, Mr. Jacobson has since seen Dr. Cantero, and told Dr. Cantero that the Zoloft was no longer working for him. This was after he had suffered the traumatic fall, fractured his skull, suffered a traumatic brain injury. He went and sat with Dr. Cantero and told Dr. Cantero, I do not feel that Zoloft is helping anymore. So Dr. Cantero prescribed Mr. Jacobson Wellbutrin. Mr. Jacobson went for the next visit and said, Wellbutrin's not working for me. So Dr. Cantero went ahead and said, all right, I'm going to prescribe you Abilify with the Wellbutrin. Taking 2 separate medications now, totally off the Zoloft. The following visit with Dr. Cantero, and you'll see in the records, Mr. Jacobson said, the Wellbutrin, a low dose of Wellbutrin is not helping me. So Dr. Cantero increased the dosage to 200 milligrams of Wellbutrin and continued the Abilify. But here's what Dr. Cantero did. He referred Mr. Jacobson out to psychiatric care because the medication, he could no longer give him any additional medication for the depression that he was suffering as a result of the traumatic brain injury that he suffered. He stopped working. He stopped driving. He stopped doing things. And the other interesting aspect of Dr. Edelin and Dr. McGovern is that, yes, we retained him as an expert to evaluate Mr. Jacobson and to conduct examinations. Yes, he was paid $350 an hour. But in doing so, you heard Dr. McGovern say, I educated Mr. Jacobson. I sat with him. I examined him. I educated him on what anxiety really was. I educated him on what flashbacks really were, okay? To put it in perspective, Mr. Deaterly has spent more money for Mr. Jacobson's care than he has himself as it relates to his emotional distress. The third question that you're going to be asked to answer is, was Mr. Deaterly the cause of the emotional distress? Absolutely not. He had pre-existing depression. He did not complain of worsening symptoms of his pre-existing depression until nearly 2 years after the incident, and only after his medical records were going to be subpoenaed. Zach was not the cause of Mr. Jacobson's emotional distress. The fact that his ex-wife committed adultery is what caused his long-term emotional distress. That's when it started. And it got worse when he suffered his accident in January of 2021. The fourth question that you're going to be asked to answer is, was Zach's conduct so severe or outrageous and so extreme in degree that it went beyond all bounds of decency? You heard 2 separate sheriff's office employees, Captain Tucko and Sergeant Achille, who both conducted investigations that were reviewed thoroughly, investigations that Mr. Jacobson himself participated in. And they found that his actions were justified based on the totality of the circumstances and all of the evidence that they had received and reviewed. They made the determination that Mr. Deaterly's actions were justified. How can someone whose actions are deemed to be justified by law enforcement officials be considered to be so severe or outrageous and so extreme that it goes beyond all bounds of decency? It doesn't. They were not severe or outrageous. His actions were not so extreme in degree that it went beyond all bounds of decency. Number 5, you're You're going to be asked if Mr. Jacobson suffered any damages as a result of the emotional distress he allegedly suffered. Again, he reported no stress until after his medical records were going to be subpoenaed. The incident had no effect on his activities of daily living. It didn't change. He still went to work, he still boated, he still fished. He went on about life as usual after the incident, just like it had never happened. He did not incur any expenses in medical care seeking treatment for his alleged distress. Mr. Jacobson has not provided any evidence to you throughout the course of this trial that demonstrates that he has suffered damages. He's going to ask you when Mr. Tempanek comes up here to award damages, but what do you award? There's no evidence in front of you. He didn't pay a single cent for the medical care, the 5 visits that he spent with Dr. Edlin. He didn't have any loss of work. He maintained his activities of daily living just as he had done before. Nothing in his life changed. The next cause of action is going to be negligence. So verdict form, self-defense, intentional infliction of emotional distress, negligence. If you find self-defense, you don't even have to get to negligence. But in the event that we get to negligence, Mr. Deaterly did not owe a legal duty to Mr. Jacobson. Mr. Deaterly used his firearm in a reasonably prudent manner. Since there is no legal duty, it cannot be said that Mr. Deaterly failed to perform that duty. That's going to be the second question under the negligence count. Since he had no duty to perform, his action in shooting the dog cannot be the cause of Mr. Jacobson's alleged injury. Third question on the verdict form under negligence. Mr. Jacobson, the fourth question, again, is going to say, did Mr. Jacobson suffer any damages? There's been no evidence to support damages. But here's where the negligence count gets interesting. Because even if you find all of those things, we're going to ask you to determine whether or not Mr. Jacobson was comparatively at fault for his negligence. Whether or not Mr. Jacobson contributed to that. He did not have his dog leashed. He failed to keep his dog leashed in accordance with Sarasota County Ordinance. If I can get Exhibit 39. Pursuant to Sarasota County Ordinance, no person shall cause, permit, or allow a dog to run at large, which I'll define for you next, unless it is leashed in any of the following circumstances: upon any public street, the property of another, or any common areas of condos and mobile home parks. It's the property of another that's relevant here. Mr. Jacobson did not own the property. The Deaterly family owned the property. If we look at Exhibit 38, on the first page, let's look at what the definition of at-large is. At-large means off the premises of the owner and not under direct control, custody, or charge of or possession of the owner. That's at-large. What does direct control mean? Let's look at direct control, Exhibit 38, page 3. Direct control means immediate and continuous physical control of an animal at all times, such as by means of a fence, leash, cord, or chain of sufficient strength to restrain the animal. So let's go back to Exhibit 39 and let's look at the legal definition of the ordinance, and let's see if Mr. Jacobson failed to comply or adhere to this ordinance. No person, Mr. Jacobson, shall cause, permit, or allow a dog to run at large, meaning that the dog is off the premises of the owner. The property was not owned by Mr. Jacobson, so it was off the premises of the owner of the dog, and not under direct control. And the only way that a dog owner can have direct control under the ordinance is if they have immediate and continuous physical control of an animal at all times via a leash or a fence. Mr. Tempanek may come up here and he may assert, well, there was a fence at the property. We've seen pictures of the fence. We've heard Mr. Williams' testimony that the dog escaped the fence. We've heard Mr. Jacobson's own testimony that the dog escaped out of the fence. It escaped the confines of the property. Is that offense of sufficient strength to restrain a dog? No, it's not, as demonstrated by the fact that the dog escaped the confines of the property. Because Mr. Jacobson failed to comply with the Sarasota County ordinance, he's 100% at fault for any negligence that may have occurred. As I mentioned at the beginning statement here, if he had had his dog leashed, you all wouldn't have had the wonderful experience of participating as jurors in this case, because we wouldn't have been here. The third and final count on the verdict form, self-defense. If you find self-defense, the rest of it goes away. Intentional infliction of emotional distress, negligence. The third one is assault. The first question you're going to be asked as it pertains to assault is, did Mr. Deaterly put Mr. Jacobson in apprehension of immediate harmful contact? Mr. Jacobson testified he never knew that Mr. Deaterly had a firearm until Mr. Deaterly shot the dog. Mr. Jacobson admitted that Mr. Deaterly never fired in the direction of Mr. Jacobson. And at the time that Zach shot the dog, despite Mr. Tympanik testifying or stating up here that Mr. Jacobson testified at the time of the shot that he was leaning in to grab his dog, at the time of the shooting, by Mr. Jacobson's own testimony, he was standing shoulder to shoulder. We dispute that. Mr. Deaterly says he's behind him, which I believe that the evidence shows. But let's look at Mr. Jacobson's testimony. It wasn't I was reaching down and chaining the dog or trying to get control of the dog. It was we were standing shoulder to shoulder. If we can play clip 76.
So she was coming to you when Zach shot Candy.
Right. She was approximately, I would think, 10 feet away from him when he shot.
She was. You said she was approximately 10 feet away from him
When he shot her.
when he shot her. And approximately how far away were you from Candy at that point?
10 feet. We were literally standing next to each other.
So he was not in front of Zach when Mr. Deaterly shot the dog by his own testimony. And Mr. Jacobson now testifies that Mr. Deaterly was brandishing the firearm. The complaint in this case said that Mr. Deaterly pointed the gun at him and discharged the firearm in the direction of Mr. Jacobson. For the first time in this trial, are we hearing that Mr. Jacobson is now saying, well, he didn't point the gun at me and he didn't fire in my direction, but he brandished the firearm at me and that made me fearful. I didn't like that. It made me fearful. It's the first time we're hearing of it during this trial. And is totally against the allegations of the lawsuit in this case. And nevertheless, Mr. Jacobson acknowledges that none of those things happened, that he never pointed the gun at him and never fired in his direction. The second question you're going to be asked with regard to assault is whether Mr. Jacobson reasonably believed that he was about to be put in immediate harmful contact. Zach testified that immediately after shooting the dog, remember as I demonstrated earlier, right-handed shooter, dog coming at you, hip shot, dog, front and back, downward action. He testified as soon as he got finished, he immediately put his firearm back to his side as he had been trained to do. And he was trained to do that during his shooting club while he attended the Florida State University. And it was during that club that he learned proper gun safety. Zach shot 3 times and never fired again. Zach did not want this to happen. You heard him testify. It's an unfortunate thing that Mr. Jacobson kept his dog unleashed, failed to go over and try to get his dog under control. And Zach had no other option but to shoot the dog. He did not want to do that, nor does he ever want to do it again. Let's look at a couple of the other inconsistent statements by Mr. Jacobson during the course of this trial. Mr. Jacobson told you on direct examination that Zach knew the dog, Zach was familiar with the dog, and that the dog knew Zach. Yet the first thing I did on cross-examination is I played a news clip from SNN. Let's look at what he said, if we can play clip 78.
Dog.
When she saw him and didn't recognize who he was or know who he was, she started barking at him.
The dog didn't know who he was. That's because the dog had never met Mr. Deaterly before, and Mr. Deaterly had never met the dog before. And again, it's important to keep in mind that had the dog been leashed, we would not be here today. And in fact, there's one last thing I want to do, and that is I want to pull up Mr. Jacobson's witness statement that you're going to see in evidence when you get the big binder with all the documents that I know you've been waiting to look at. You're going to get it. I believe it's Exhibit 5. And let's look at what Mr. Jacobson said in his witness statement. Mr. Jacobson stated, and I quote, "As I started to move Candy to get her under control, consistent with what he told Sergeant Achille that he had never seen his dog act that way before, consistent with his statement to Captain Tutko that dog was doing what dogs do, that Captain Tutko took as saying that that the dog was protecting Mr. Jacobson. He acknowledges that his dog was not under control. He failed to do anything to get that dog under control. And despite pursuing alternatives, Mr. Deaterly was unfortunately left with the last resort of shooting the dog because Mr. Jacobson did nothing." I would ask the jury to find that Mr. Deaterly acted in self-defense in this case. But if you find that he did not act in self-defense, I still ask you to not award anything to the plaintiff for any of the other causes of action for the reasons I just said. Thank you.
Defense counsel talked to you about how we wouldn't be here if he was on a leash. She was on a leash. Yet we heard evidence from Leanne Novak, who interacted with the dog unleashed. We're not here. Leanne Novak isn't the plaintiff. Candy didn't do anything to her. Unleashed when interacted with Richard Muldahill. Unleashed when it interacted with Brian Williams. We are not here because Candy was unleashed. She had been unleashed on that property more times than any of us can count. We are here because the defendant shot and killed her. That's why we're here. I agree with defense counsel. You are a resilient jury. These last 2 weeks have not been easy. But yet you're still here. And as a resilient jury, you're not going to believe what the defendant has tried to sell to you today. And I mean last week. The story he told, which was in direct contradiction what he told police immediately after the incident. You just said he told you that Mr. Jacobson wasn't doing anything, yet they just pulled up his witness statement. He was trying to get Candy under control. That's what they just brought up. Mr. Kessler talked about how Mr. Deaterly shot 3 shots point blank from the hip. Okay. But remember when the defendant testified, talked about his marksmanship scores? He was very proud of those. Yet that dog is 2 feet away and not inches away from his gun. Yet he misses twice from point blank range. You saw the demonstration Mr. Kessler did. Shoot from the hip, dog's here. That dog, based on the height and weight as described, a foot. Someone with marksmanship scores, like Mr. Deaterly so proud of, misses from a foot? Twice? Come on. That's because that didn't happen. That doesn't even make sense. Talked about the criminal investigation. It's like, well, they didn't find enough to charge him. With that investigation? Well, understandably so. The lack thereof. And remember, that was a criminal investigation. The standard is beyond a reasonable doubt. That's not the standard in a civil case. It's the greater weight of the evidence. What does the evidence say? Does the evidence say that the defendant was remorseful? He said he was. Yet he wasn't immediately after Mr. Jacobson. At all. Taunting him, brandishing the firearm, yelling obscenities, which I don't need to say. They've been said enough. And then tries to tell you about how remorseful he is today, last week. Yet that's not who he was immediately after he shot and killed Candy the dog for barking. Heard a lot about the Unleashed, and that's why we're here. Like I said, those other individuals who testified who encountered Candy the dog, Unleashed, never shot her. She was barking at all of them. They never. Self-defense. The dog's actions led Zachary Deaterly. Now, let me back up. Zachary Deaterly was justified in destroying or injuring Rod Jacobson's dog for purposes of defending himself against harm threatened by the dog if, one, the dog's actions led Zachary Deaterly to know or reason believe that the dog will inflict such harm. Based on what? Dog never even laid a paw on Mr. Deaterly. Not a bite mark, not on anyone. Those people who testified, they worked on the Deaterly property. They worked for his father. And none of them had even a paw laid on them. Not a bite mark. So how would you reason believe the dog is barking? I don't know how you get there. 2, if destruction or injury is reasonable in the view of the gravity of harm threatened. Talked a lot about an attack. What attack? Running around and stopping and barking? That's literally every neighborhood in the United States. Yet Candy never broke Mr. Deaterly's personal space. It wasn't until Mr. Deaterly actually kicked at the dog in the head that that's the closest they ever got when the defendant tried to kick. And successfully did. The gravity of harm threatened. I don't see it. 3, if Zachary Deaterly reasonably believes that that harm can only be prevented by the immediate destruction of the animal. You heard his testimony. He couldn't go to the north. Okay. Because of the waist area. He couldn't go to the east because he would have been pinned against the truck. Okay. The dog controlled the south ground. Okay. What about the west? The west where Mr. Jacobson, by Mr. Deaterly's own testimony, that's where he saw him. That's where he was. And he suspected this dog was Mr. Jacobson's. So he doesn't walk over there while keeping his eye on the dog. Reason believe that the harm can only be prevented by the immediate destruction of the animal. All of those individuals interacted with Candy the dog. Not one of them deemed her actions could only be prevented by the immediate destruction of the dog. Talks about how he didn't spend any money. There were no damages from this incident. Well, that's not entirely true. As you heard, after Candy was shot, she had to go to the vet for emergency surgery in Sarasota. $2,700. That's what he had to pay. Goes to Tampa, $5,500. He wouldn't have had to pay it, but for the defendant shooting his dog. Talks about how he doesn't have emotional distress. Really? Dr. Edlin seemed to think so. His doc, who he was referred to, told him exactly what he was going through. Seeing his dog shot and killed over and over again. He broke it down for you beautifully about what somebody with post-traumatic stress disorder has and why they have it. And they say, Dr. McGovern's like, well, Dr. McGovern says, no, he doesn't. Dr. McGovern, who's never been qualified as an expert to speak on post-traumatic stress disorder, never testified to it, and is paid for by the defendant himself, as opposed to Dr. Edlund. Talks about pictures of the dog. This dog was so aggressive, vicious, that she deserved to be shot and killed. That's what Mr. Deaterly is. This dog, on the defendant's own grandfather's boat. Vicious, agreed. Dog that went absolutely everywhere with Mr. Jacobson. Dogs to job sites, to the boat, to the Deaterly property. And it did countless times. Never any incident with anyone. Never bit anyone, never jumped on anyone, never laid a paw on anyone. That dog. That dog that Mr. Deaterly did this to. Gunshot wound, clearly. Left side, and then another suspected one to the right elbow. If he's firing from the hip there, how does he hit on the right side of the dog? That's the claim. He wouldn't. You are a resilient jury, because I know you don't actually believe the story he tried to tell you last week. That was in direct contradiction to himself. Not just Mr. Jacobson's version of events, himself. His actions. Willful, extremely reckless, negligent, grossly negligent, and above all, malicious, is what actually caused the death of Candy the dog. Something that Mr. Jacobson lived with for years and still lives with to this day. Talk about, it's like, oh, well, if he was on the property unleashed, that's an absolute defense. Well, no, there's a fence there. That also statute says dogs and cats leashed. I wonder how many cats are leashed up nowadays. Greater weight of the evidence. Facts and logic support what Mr. Jacobson says, and the defendant's own words immediately after the incident that he wholeheartedly admits to. That's who Zach Deaterly really is. That a man who just shot a dog responds, "You're damn right I did." After he just shot this guy's dog. Effing idiot. Moron. That guy. That's who he really is. We're asking for $450,000 in damages. And we're asking you to hold him liable and accountable. Thank you very much.
All right, folks. It's almost 4 o'clock. I think what we're going to do is recess for the day. I'm going to ask you to be here tomorrow at 9 o'clock. Again, I remind you, please stay away from any media. Don't do any research. You've heard the facts from the evidence. You've heard the lawyers. But we have an important piece to give to you tomorrow, which is the law, that you have to consider through the lens of the law, the facts. I'll give that to you tomorrow. We'll go over it, make sure you understand it, and we'll present you with a written verdict form that you can fill out as a series of questions. And that will conclude your service after you've done that. All right? Go ahead, you take charge of the panel. I need to see the attorneys.
Jurors exiting, please leave your notepads on your chairs.
Okay. Exhibits that were not part of the binder. We've got the notice to produce to Dr. Marcantano, and we got the map with the marks on it.
That's correct. I believe I gave Madam Clerk copies to put into the record, Your Honor.
We've got those, and those will go with the jury. How do you want to handle the clips? You played video clips, and you've got some audio and visual things that need to be somehow part of our record.
I would just say, Your Honor, if they request to see him, we can bring him in and show him to him.
Well, I'm talking about preservation of the record now. I'm not talking about the jury having to review it, but they've shown document or material before the jury that is not in a tangible form that we can attach to the record.
And Your Honor, I believe that Richard has done a very nice job of being able to transcribe what is being played in the clips. So the actual statements that are being made in the clips are preserved for the record. They are part of the record.
Okay, so you see no need to include the video portions, just the audio?
Well, the audio portions that Richard has put down into the transcript and made it part of the record, I don't think we need to have the actual video clips, Your Honor.
That's fine with me.
No issue, Your Honor.
Okay, great. Anything that you want to add? I do want you to spend some time. I've been through enough of these that I worry about automation and preparing jury instructions. Just make sure they're good, okay? There's no mistakes made in it. And then we can go do our business tomorrow.
Perfect. Thank you, Your Honor.
In
This set of